Very warm welcome to all of you. Thank you for dialing in and taking the time to be with us this morning. I really appreciate that. My name is Richard Broadbent. I'm a director in the environmental law team here at Freeths, and prior to that, I was at Natural England, head legal at Natural England before joining Freeths last year. So today we're going to talk about marine law to provide you with an overview of current and proposed steps for marine environmental law in the UK. And there's a lot here. There's a lot of detail here, and I think the benefit of this will be to let you see how the things connect together, the connections between these different concepts, how it fits together. That's what we're trying to give you a feel for today. It's going to be recorded, this session, so you can come back. But as my colleague Tom was just saying, if you've got any questions, please feel free to ask those questions to us. Some of you already have done in advance of this, but put those into the chat function. Hopefully we'll have some time at the end of the presentation today to answer those questions for you. If we don't answer them, please email myself, my colleague Helen, and we'll be happy to answer those questions for you. So a little bit about the team here at Freeths. So here's some pictures of those people in the team. That's myself there. So this involves in the planning and environment team, we have planning lawyers and environmental lawyers. And we've got a mix here of solicitors, planning consultants, but also in Alison Ogley, an advocate as well. So we do the full range of work in this area. And we have 27 people in our team, and we're based in offices across the country: London, Nottingham, Bristol, Sheffield, Leeds, and Liverpool. So that's a little bit about the team. And I'm going to hand you over to Helen, who will be leading you through the bulk of this presentation today.
Hi, thanks, Richard. Just an introduction to me. So I'm a solicitor in the environment team at Freeths, but prior to qualifying as a solicitor, I was actually a marine mammal scientist, and I worked as an environmental consultant, also primarily with offshore developer clients. So that's where my interest in marine environmental law really stems from. So as Richard mentioned, we are going to make a recording of this talk available, and also a copy of the slides will be provided. A lot of these slides have links that you'll then be able to access. So I thought today we'll start with a brief recap of the pressures on the marine environment, and then the rest of the presentation will look at the current policy and targets in relation to the marine environment, both in respect of protection and recovery, but also targets for renewable energy. We'll look at a number of current and proposed mechanisms to meet these targets, including focusing on the role of marine protected areas, proposals with respect to reducing consent times for offshore wind, marine net gain, and we'll end with a look at the recommendations made in the recent report on marine mammal protection. So there's a lot going on with respect to marine environmental law and policy, and therefore, as Richard said, today, over the next 45 minutes or so, we're primarily going to be giving an overview of all of these many current and proposed strategies, policies, bills, targets, and recommendations. And the intention of today is to sort of set out how all of this will potentially fit together in helping to protect the marine environment and to deliver offshore energy. So just start off with a brief recap of the marine environment and the UK marine environment. So we've been using the oceans for centuries. We use them as a source of food for natural resources, as a medium for transport, as a place to dispose of waste, and increasingly now also as a source of energy. And today, though, the health of our oceans is in decline, and the causes of this decline are varied and complex. And this is demonstrated in this image from the United Nations Sustainable Development Goal 14. And the UK has some of the richest marine ecosystems in the world, and it's an important location for many different species. For example, the British Isles is home to over 20 species of breeding seabird. Our coasts support internationally important breeding populations of a number of seabird species, including the northern gannet, Manx shearwaters, and great skuas. We have over 20 species of cetaceans, which are whales, dolphins, and porpoises. And some of these occur year-round, such as harbour porpoise and bottlenose dolphin. And other species visit regularly, such as minke whales, orcas, and humpback whales. And the UK is also home to a third of the world's grey seal population. And we're also increasingly seeing species which haven't been encountered in the UK before. So over the past few years, I'm sure you've all seen on the news stories about a number of walruses visiting our coast. So what is the UK marine area? I'm just going to leave this slide up and just briefly discuss some of the terminology that's used to describe the UK marine area. All this terminology is set out on the next slides. So the Marine and Coastal Access Act defines the UK marine area as consisting of the territorial sea, which is adjacent to the United Kingdom, and that's shown by the blue line on this image. And it's the zone extending up to 12 nautical miles from the baseline. It also includes the exclusive economic zone, and this is shown by the yellow line on the image, and that's the zone extending from the outer limit of the territorial sea up to 200 nautical miles from the baseline or to the median line with another state's exclusive economic zone. And it also includes the area within the limit of the UK sector of the continental shelf. So these next slides just set that out in a bit more detail for you to have a look at after the presentation today. So I'm going to pass back over to Richard now, and he is going to run through some of the policy and targets, some of the environmental targets, and some of our net zero and renewable energy targets.
Great, thank you, Helen. So now you've got a sense of the context here for the marine environment and why it's so important. Let's look now at what environmental law and policy is doing about that. So in the Environment Act 2021, there's provision there under Section 1(2), whereby the Secretary of State has to set at least one long-term, so that's a 15-year target with required standards and required dates for each of those standards to be met for 4 areas, and that's air quality, water, biodiversity, and resource efficiency, and dealing with waste as well. So those 4 areas need to have their own targets for them. And in addition to that, under Section 3 of the Environment Act 2021, there's a species abundance target. And these targets are meant to set a new compass, a new sort of focus for environmental law and policy. Politicians tend to like targets because they galvanize bureaucracies into action to achieve them. So there's a political impetus behind this. The problem with targets is that we're not particularly good at meeting them. And so that's the risk there. And ways that you try and mitigate that is by having interim targets on your sort of milestones on your way to achieving those targets. So when it comes to the marine environment, we have a target for that set out. And this was set out in secondary legislation, which accompanied the Environment Act. Ironically, the government missed their target for the production of the secondary legislation on targets. But earlier this year, in January this year, the secondary legislation for these targets was produced. So for biodiversity in the sea, the target is for around marine protected areas, and there was a proposed target included in the consultation on what those targets should include, and that's included in this table here. But the final target is that 70% of the designated features in marine protected areas network is to be in favorable condition by 2042, with the remainder in recovering conditions. So 70% in that favorable condition target, and the others heading towards that and not essentially in decline. That gets set out in this legislation here, and you have a helpful link to that. And to try and unpack what that means, in that second legislation, it describes what is favorable condition, which is the quality and quantity and distribution of its supporting habitat, the quality and the quality of the natural supporting processes on which it relies, the availability of prey and the composition of its population in terms of distribution and size, such as to ensure the population is maintained in numbers enabling it to thrive. For those of you familiar with European sites, the same, similar ideas of favorable conservation status, when sites are thriving, robust, able to cope with impacts on them. And then what does recovering condition mean? Well, it means that the feature is not in favorable condition, but the measures necessary to remove or manage all relevant impacts on that feature have been implemented. So that's the definitions here, and there could be critiques of those definitions, but those are definitions that have been used in the secondary legislation. And if you open up that secondary legislation, you'll see it's a huge document, because what it does is lists out all these marine protected areas for which this applies. And then accompanying this, under Section 8 of the Environment Act 2021, there's a duty on the Secretary of State to produce environmental improvement plans. Now we have the first of those, that's the 25-year environment plan published back in 2018, which set out like a vision for what the government wanted to do with the natural environment, leaving it in a better condition than was found for future generations. That vision was set out in that 25-year environment plan. And then in January of this year, we have the second published environmental improvement plan, which aims to put in place plans to deliver on that vision. That's essentially what it's trying to do. And it does that around this apex goal of improving biodiversity. That's the main target here. And that the target set out in that second legislation is incorporated into this environmental improvement plan. So you can see it replicated there as the long-term target. But then in addition to that, we also have these interim targets as well. This one being set for 48% of designated features and MPAs to be in favorable condition, the remainder in recovering condition by the 31st of January 2028. So by 2028, we can get our first milestone to see how we're doing in terms of achieving this long-term target that's being set. So those are really important policy areas, and it's getting things moving within government to achieve that. In addition to that, there are other strategies to be aware of too. So this is the targets for offshore renewable energy, the net zero target. And under this, the key policies are is that by 2035, the UK will be powered entirely by clean electricity, subject to security of supply. And that caveat goes in there because of recent conflict in Ukraine. So secure a final investment decision on large-scale nuclear power plants. That's part of this too. But importantly, 40 gigawatts offshore wind by 2030. It's huge targets here. And also moving towards 1 gigawatt of floating offshore wind by 2030. So these are important drivers to driving decision-making, planning decision-making around what's needed in order to achieve that net zero strategy. And in addition to this, back in April of last year, we had the British Energy Security Strategy. And in that, of relevance to the subjects, the matter that we're talking about today, is reference to smarter planning. With smarter planning, we can maintain high environmental standards while increasing the pace of deployment of offshore wind by 25%, and an ambition to deliver 50 gigawatts by 2030, including up to 5 gigawatts of innovative floating wind. So these are the drivers behind offshore wind. It was noted in this document, though, that it takes a great deal of time between concept to operation of these offshore wind farms, on average around 13 years for that to happen. And so in this British Energy Security Strategy, there's discussion of how to address this going forward, and that's summarized on this next slide for you here. But essentially, what they're proposing is to reduce the process time, that 13-year process time, trying to cut that in half by doing various things. So reducing the consent time from up to 4 years down to 1 year, strengthening the renewable and national policy statements to reflect the importance of energy security and net zero. Those national policy statements are very influential in decision-making on these things. Making environmental considerations at a more strategic level, allowing up to us to speed up the process while improving the marine environment. So taking not a case-by-case basis, but a strategic level approach to this. Introducing strategic compensation environmental measures. So developers aren't providing compensation individually, but at a strategic level. Reviewing the way that habitat regulations assessments are carried out, because there are concerns about the impacts of offshore wind on protected sites, protected species in the marine environment. And then introducing a new offshore wind environmental improvement package, including an industry-funded marine recovery fund and nature-based design standards to accelerate deployment while enhancing the marine environment. So these are the ideas that are being put forward in this strategy to try and unlock this. Great, Helen, I think back to you.
Cool. Thanks, Richard. Yeah, we'll come back to some of those concepts for the next part of this presentation. So for the rest of this session today, what we're going to look at are some of the current and proposed mechanisms to try and meet these targets, both of the environmental improvement target and also the offshore renewables and net zero targets. So I thought we'd start with a look at the role of marine protected areas. So there's several types of marine protected area in the UK, and these are in combination intended to form an ecologically coherent and well-managed network and contribute to the effective conservation and sustainable use of the UK's marine environment. And the UK agreed to achieve this MPA network under both the UN Convention on Biological Diversity and under the OSPAR Convention. So some of these marine protected areas that we'll talk about mostly today are special areas of conservation, which are designated to protect habitats and species of European importance, such as the bottlenose dolphin pictured on this slide, special protection areas, which are classified to protect bird species of European importance, as well as regularly occurring migratory birds, and marine conservation zones. And in addition, we now have 3 highly protected marine areas, and these were designated just in July of this year. This is a really helpful tool. I just wanted to share it all with you. JNCC has produced a marine protected area mapper. It's an interactive resource, and it displays MPA boundaries in all UK and Crown dependency waters. It also gives protected feature information for sites within the UK waters. So it does demonstrate some of the areas that I've flagged on my image to show you. The purple are the marine conservation zones. The dark blue are SACs with marine components. And the pale blue with the dashes are seasonal protected areas for harbour porpoise. And JNCC also calculates statistics for the whole of the UK marine protected area network. And this is in order to assess progress, primarily in designation. And as of July 2023, the UK has 377 MPAs covering an area of 338,729 square kilometres and comprising 38% of UK waters. So you'll see the number of MPAs in the inshore region is much higher than in the offshore region. However, the MPAs in the offshore region cover a much larger area. So today I'm going to focus on marine conservation zones as well as SACs and SPAs, and have a look at the development in these MPAs, and then look at the creation of some bylaws and a very, very brief look at highly protected marine areas. So marine conservation zones, or MCZs, are designated under the Marine and Coastal Access Act, and SACs and SPAs are designated under the Habitats Regulations and the Offshore Regulations. And certain activities which are capable of affecting the protected features of an MCZ, or of which have a significant effect on an SAC or an SPA, must be authorised before an activity can commence. So responsible authorities are those with decision-making powers. They must assess the impact, either alone or in combination, on marine protected areas of any plans or projects before consenting that plan or project. And for each of these types of MPA, there's a process for assessing impacts, for considering alternatives, looking at benefits, and also looking at compensation. So for MCZs, the responsible authority, this wording comes from the Marine and Coastal Access Act. The responsible authority may not give consent unless it is satisfied either that there is no significant risk of the Act hindering the achievement of the conservation objectives stated for the MCZ. And if the authority can't be satisfied of that, it must be satisfied that there's no significant risk, it must be satisfied that there is no other means of proceeding with the Act which would create a substantially lower risk of hindering the achievement of those objectives. And the benefit to the public of proceeding with the Act must clearly outweigh the risk of damage to the environment. And the person seeking the authorisation must undertake or make arrangements for the undertaking of measures of equivalent environmental benefit to the damage. That's essentially compensation. And this slide provides a brief reminder of the HRA process for European protected sites. So that's your SACs and your SPAs. And so for these sites, the responsible authority may only give consent to a plan or project only after having ascertained that it won't adversely affect the integrity of the site. The habitats regulations and the offshore regulations provide for a derogation, and that allows plans or projects which affect an MPA to be approved if, in spite of a negative assessment of the implications for the site and in the absence of alternative solutions, a plan or project must nevertheless be carried out for imperative reasons of overriding public interest. And where this plan or project is agreed to, notwithstanding this negative assessment of the implications for the site, the appropriate authority must secure that any necessary compensatory measures are taken to ensure the overall coherence of of Natura 2000 or the national site network. So you can see both of those assessment processes end up with compensation ultimately. And so in considering an application for development affecting one of these MPAs, a responsible authority can therefore decide to consent to a development if it's satisfied that proposed compensatory measures can be secured and delivered and that these are sufficient. So compensation in the marine environment is quite a tricky concept and also relatively novel. It's not used as much as it's used in the terrestrial environment. And between July and September 2021, DEFRA sought views on their best practice guidance for developing compensatory measures in MPAs, and this focused on MCZs, SPAs, and SACs. And the summary of responses was published in December 2022, and DEFRA announced that they would publish updated guidance on this by March 2022, and it's not been published yet. But we'll have a look at the responses that were made to the consultation and have a read through. It's sort of the draft guidance, really. It's quite useful. Most respondents to the consultation were in support of some of the key concepts, so that a hierarchy approach for compensatory measures. And what this is, the underlying principle is that compensatory measures that benefit the same feature which is impacted by the development will be the most preferable, as they balance the damage caused to the environment. And then each step down the hierarchy moves away from like-for-like measures, and therefore may decrease the certainty of the success of the compensation, and it will also therefore increase the extent of the compensation required. The location of the compensation, and that is that the responsible authority should consider compensatory measures based on sequential preferences. So the preference is that the measures replicate or benefit the same feature within the affected site. And secondly, that they will do that outside of the affected site. So the preference is for it to be inside. That the compensatory measures should be delivered at a ratio of higher than 1:1. And the reasons given is that this will increase confidence in site conservation objectives being achieved and also coherence of the MPA network. And regarding timing, that a protected feature shouldn't be impacted before compensation is secured. So ideally, measures should be in place, functioning and contributing to the network before development begins. And a lot of respondents stated that the current guidance is very unclear. It's unclear on specific mitigation and compensation measures relating to the marine environment. And what they've requested is examples of compensatory measures that are tailored to the marine environment, some examples of additionality in practice, and clearer advice on how to operate effectively, really. When this draft guidance came out in 2021, compensatory measures were very rarely used in the marine environment, and they were much more frequently found in the terrestrial environment. But with all of the increasing activities taking place in the marine environment, since the publication of the draft, we're starting to see the process of securing these compensatory measures becoming increasingly necessary in order for developments to obtain consent. And one of the most high-profile examples of this is Hornsea 3. Hornsea 3 offshore wind farm received planning permission in December 2020. And as part of the development consent order, a requirement was included for ecological compensation measures for black-legged kittiwake. Ørsted commissioned 3 industry-first, innovative nearshore artificial nesting structures. There's an image of one on the slide here. And these have been specially designed to house kittiwake. So you can read more about this. I've put a link in the slide here and tells you more about these structures and the requirement for compensation. And just recently in July of this year, Hornsey 4 was granted development consent order, and that also required compensation. So the MMO, the Marine Management Organisation, is also responsible for managing the impacts of fishing and non-licensable activities on marine protected areas. The MMO has powers under the Marine and Coastal Access Act, and now increasingly has increased powers under the Fisheries Act 2020 to make bylaws, and these are to further the conservation objectives of MCZs as well as SACs and SPAs. And in June of 2022, the MMO introduced new bylaws to protect 4 offshore MPAs from damaging fishing activity. And after extensive consultation, these bylaws were introduced, and they prohibit the use of bottom-towed gear within these 4 MPAs. Between January and March of this year, 2023, the MMO held a stage 2 consultation to seek views on proposed bylaws to manage bottom-towed fishing gear in a further 13 MPAs. And at the same time, they opened a stage 3 call for evidence, asking stakeholders to submit any additional evidence and share views on the impacts of fishing in another 41 MPAs. And the MMO is also currently considering 5 what they call stage 4 MPAs, and these are those protecting highly mobile marine species such as seabirds and harbour porpoise. And highly protected marine areas, there was a consultation on these, followed the Bennion review. These are areas of the sea that allow the protection and full recovery of marine ecosystems. They're fully protected. The first 3 highly protected marine area designations in English waters came into force on the 5th of July 2023. The image on this slide is taken from the consultation, and it shows 5 sites. So 5 were originally proposed, but only 3 were chosen to go forward. The 3 chosen to go forward were Allenby Bay, the northeast of Farnes, and Dolphin Head. So you can see Allenby Bay is just up on the Scottish border on the west coast. Northeast of Farnes is slightly offshore on the east coast, and Dolphin Head's on the south coast. Quite small areas in the grand scheme of things, but they will be afforded full protection. And these 3 highly protected marine areas form the initial pilot phase and will inform sort of future policy on this. So now we're going to have a look at the offshore wind environmental improvement package. So following on from Richard's earlier slide about the British energy security strategy, this stems from that. So we'll touch on some of the points that Richard raised there. So the government is seeking legislation to deliver what is referred to as an offshore wind environmental improvement package. And the aim of this is primarily to support the accelerated deployment of offshore wind, but at the same time making sure that it's as least damaging as possible on the environment. So the reminder, the target set in that was to deliver up to 50 gigawatts by 2023 isn't correct. That's now. I'll change that before we send this back out. And so the energy bill, the government's proposing to do this through the energy bill, was previously referred to the energy security bill, was introduced into Parliament on the 6th of July 2022. And this builds on the commitments in the British energy security strategy. And on the 9th of July 2023, the amendments were proposed at the committee stage of the energy bill that would implement the offshore wind environmental improvement package. And also on the 9th of January, the government published a policy statement on the offshore wind environmental improvement package. And this explains why the government is introducing the powers in the package and how it's going to use those powers. So the government's seeking amendments to the energy bill for a number of measures for which primary legislation will be required. And this includes the making of regulations about the assessment of the environmental effects on protected sites of the offshore components of the marine infrastructure of offshore wind, basically. So the turbines and the cables and anything else that's going to take place in the marine environment. Also on strategic compensatory measures, and also on making regulations to introduce one or more marine recovery funds. So we just look at the strategic compensation, well, we've just looked at the guidance on that, and what the energy bill is going to propose is new legislation to enable the delivery of strategic compensatory measures. And this would, the aim of this would be to consider compensatory measures upfront and strategically through the HRA legislation, and in order to amend the habitats regulation assessment legislation, that'll need to be done through primary legislation. And the goal is ultimately, what it comes back to, is to reduce the time spent trying to resolve these compensatory issues and speed up the consenting process for offshore wind, but without losing the environmental protection elements that we get from that. It also proposes a new industry-funded marine recovery fund, and the aim of that is that that will actually help to support the delivery of strategic compensatory measures. The guidance, when it was published, stated that the fund is intended to be operational by the end of 2023. It'll be an optional route for developers to pay into to discharge their compensation obligations. So it's quite a controversial approach, but one that will, and we'll come onto this with when we think about marine net gain as well, is it's the quickest approach to get this started. So it's worth noting, though, that developers, they will still be required to undertake an environmental impact assessment and a habitats regulations assessment for their projects ahead of receiving a development consent order. So where are we with all of this? Well, the bill's currently at what's referred to as the consideration of amendments stage. It's scheduled to be read by the Lords again on the 18th of October, so in a couple of weeks' time. And the policy statement also states that, indicates that the government's going to develop the draft regulations and any other aspects of the offshore wind environmental improvement package alongside the legislation in the energy bill. So it was a whistle-stop tour through an awful lot of content about what's going on in the marine environment. Something else that's very high profile now, Richard's going to tell us a little about, is the marine net gain regime.
Yeah, thank you. Thanks, Helen. So marine net gain, and we're all getting ready for terrestrial biodiversity net gain. The mandatory starting point for that has been shifted, as some of you all know, from November to January, and hopefully it won't shift again. But now we're going to talk about marine net gain. There was a consultation on this, sort of in the wake of the talk about biodiversity net gain on land. A consultation on this back in September 2022 on marine net gain. That's when it closed. And what the consultation was trying to do is probe this as a concept. So, what are the core principles for marine net gain? How would that operate? Seeking views on whether to mandate it, as we've been looking to mandate biodiversity net gain on land. Seeking views on the scope of the marine net gain. Seeking views on how net gain could be applied in the challenging environment that is the marine environment. We had a summary of responses from government back in March 2023, and we're expecting the government's response imminently on that. So we'll keep you posted. We've been very much involved in that consultation. We provided a consultation response on that. We're following it very closely, and we'll continue to follow this closely as an area, writing about it and letting people who clients aware of what's going on. So, what is marine net gain? Well, it would apply to developments or infrastructure forming part of development below the low water mark. And this diagram here helpfully sets out how that would work. So you can see where terrestrial biodiversity net gain regimes end, which would be introduced, which when it becomes mandatory, it becomes mandatory through amendments to the Town and Country Planning Act, as you can see here on there. But then marine net gain would apply below the low water mark. And I think the important thing to really grasp here is that this is being developed from first principles. It's not a copy and paste of the biodiversity net gain regime from the terrestrial environment into the marine environment. That just wouldn't work. It's too different. So a first principles approach needs to be taken here to understand how to apply this sort of concept in this environment. And the driver behind this is about species abundance, that species abundance target, trying to improve biodiversity, the targets around that. So I think it's an idea that will continue to gain some traction. It's just figuring out how to do that. And some of the concepts that have been talked about here, and which we were commenting on in the consultation response on marine net gain, includes things like applying it to species as well as habitats. So biodiversity net gain is very much about habitats. Habitats is a proxy. There's a metric for that. Well, there's a concept here that with marine net gain, it would have to apply to species as well as habitats because of the mobility of species in the marine environment. It would also include things like pressure reduction and active restoration. Well, what does that mean? It means things like removing marine litter, which covers up the marine environment, removing that reducing that pressure, and then doing things as well like active restoration of seagrass and kelp forests and marine habitats. There's also this concept that this would be done at a strategic level or at site-based interventions. And from what Helen was saying, when it comes to looking at maybe a strategic approach to compensation for impacts in the marine environment, maybe that strategic approach is the right one to take, again, given the peculiarities of the marine environment and the challenges associated with it. And quite frankly, there may be more to gain for biodiversity if a more strategic approach is taken with regards to it. So if you want to read a little bit more about that, like I said, we've been following this very closely. We've written an article about marine net gain. There's a link to it there, which you're very welcome to read. And and as I said, in the natural capital team, we'll continue at that Freeths. We'll continue to follow this closely. Great, thanks. Back over to you, Helen.
It would end with one of my particular favorite topics. I thought I have to include this in here, and it's the. Hang on, let me move the slide. It's the recent effort recommendations and report on protecting marine mammals in the UK and abroad. So this report was published in June, and it followed an inquiry which took place towards the end of 2022 and at the start of 2023, where lots of marine mammal experts spoke and acted as witnesses and gave evidence about the status of marine mammals in the UK and abroad. And this comprised scientists, policymakers, and a lot of other experts as well. And this report was published in June, and it makes a number of recommendations. So, for example, in the short term, it recommends that seals, it doesn't define anything further than seals, should be added to Schedule 5 of the Wildlife and Countryside Act 1981. And this will make them nationally protected species. And it recommends that this is done as soon as possible. Just going back and throwing in some more acronyms, the quinquennial review, the 7th quinquennial review on the schedules of the Wildlife and Countryside Act took place a number of years ago now. And a lot of organisations put forward in their responses to that pinniped species should be included on these schedules. So the responses to that consultation haven't yet been published either. So it's quite reassuring to see this recommendation made in the marine mammal report. In the medium term, for DEFRA to take urgent steps to close the loophole that allows the transit of cetacean products to UK ports. So this can include all sorts of things such as whale meat or parts of cetacean. So, in some instances like narwhals, tusks. This doesn't happen too often, but it is still there and there is still a loophole. So the government recommended that be closed in the medium term. And in the long term, the government brings forward primary legislation on marine mammal protection. All of these are obviously of great interest to me, but this aspect on primary legislation of marine mammals is particularly exciting to me, and it's something I've been following for a number of years. So there's a link here on the slide to an article that we wrote at Freeths, which discusses the current status of marine mammal legislation in the UK. So marine mammals are currently protected through a patchwork really of legislation. They're added into schedules and of legislation that's primarily focused on terrestrial species, and arguably it's not very effective for their adequate protection. So the opportunity to advocate for and being, potentially having in place primary legislation on marine mammal protection is really, really exciting, and it's great that it's been recognised by the government. So a couple of countries have such primary legislation already. So the US is an example with their Marine Mammal Protection Act, and New Zealand also have primary legislation for marine mammals. So I think it's quite an exciting time and opportunity for the UK to potentially take a really innovative approach to this, and to combine it with everything that Richard and I have just discussed over the past 40 minutes or so. All of these targets for our marine environmental protection are looking at making more use of our oceans for getting marine energy from marine sources, but making sure that we protect our species. And we are an island, we're surrounded by marine mammals, we've got 20 species known to occur here. So I think I find it quite exciting that this is proposed. We're still waiting for the government's response to these recommendations, and I've heard people from within the government saying things like, well, we've already got adequate, it's all there, we'll just pull it all into one piece of legislation. And to be honest, I think we need to go further than that. I think if we want to be serious about meeting our targets and protecting our species, then this is a perfect opportunity to do that. And I just wanted to highlight this as an example of an inquiry that's gone ahead, that's been pushed for and focused on, and we've got the outcomes of here. So yeah, if you do want to read more about marine mammal protection, there's a very lengthy article on our website here, and of course we're happy to talk to you more about that. So I think that brings us to the end of our presentation today. So we've got loads of time for some questions.
We have some questions as well.
Yeah, I've seen some questions in the chat already, and so these questions refer back to the target regulation. So I'm just going to take us back to that slide so we can have a look at that wording.
Oh, that's helpful. Yeah.
It was quite near the beginning.
And please, feel free, now we've come to the end of the presentation, feel free to type in some more questions. We're happy to answer those for you.
This is the wording, and the wording I used on this slide is the wording that relates to, I've just got the full set of the regulations open up here. It relates to protected features in an SAC, which is a species of marine fauna or flora. So that's the favourable condition wording for those kind of species. And the example used in the exact wording of the regulations is where the population feature is a grey seal, harbour porpoise or harbour seal. It is free of disturbance of a kind likely to have a significant effect on its use of the site. And the question asked, and I think it's a really important question, what's the definition of significant? And unfortunately, the regulations don't provide this. And we see the word significant used quite a lot in environmental law. And Richard, what do you think it has to be sort of read?
Yeah, in my view, it would be read as activity that causes death or injury to marine mammals.
And backed by evidence, I think, as well.
That's right. Yeah, activity that causes the marine mammal to cease using an area would be significant disturbance, or to alter its behavior in a manner that's likely to impair its ability to survive, breed, or feed. Those are the kind of criteria that you'd be looking at here, I think. And the causes of that would be things like bycatch, prey depletion, underwater noise, that kind of disturbance, habitat degradation. Those kind of things I think will have the quality to have an impact. Collision impacts, for example, on species. I think those are the kind of things that have an impact, which is sufficient to have that kind of significant disturbance, death, injury, those sorts of categories of harm.
Yeah, I think yeah, and I think with using words like significant, it's almost telling, saying we provide as much evidence as possible, and then sort of making the argument for monitoring baselines, and I think that all of that is something we are doing, but we need more support from the government and the local authorities to to have that. And that's something actually the Marine Mammal Report recommends as well, is it recommends more monitoring, especially of cetaceans. And in that case, that way we'll be able to sort of gain a better understanding so that we can determine what significant means. But yeah, and it's not defined, but if it was defined, it probably wouldn't be defined very well, and you run the risk then of a definition excluding things rather than making it more inclusive. So I think it's probably open to making an argument that something is significant.
Yeah, but wildlife impacts. I mean, he's just talking about baselines there, and the lack of monitoring, even in terrestrial sites. I know there's a lack of monitoring for IISIs, say, over the last 10 years, lack of funding essentially. That impairs your ability to have that baseline against which to assess impacts. But my gosh, in the marine environment, it's even more challenging, isn't it? I mean, it's very difficult to assess some of these baselines. I would imagine.
Yeah.
All right.
So there's another question, and it says at the recent Westminster Environment and Transport Forum, which we attended, as well as watching on that, there was some discussion about the use of a natural capital approach to marine biodiversity net gains, evaluation of natural capital impact, and use of a carbon-like trading scheme to offset harm. Do you think this is a realistic approach in the marine setting?
Yeah, I mean,
yeah.
I quite like the natural capital idea. I mean, I know it has its critics, but as a way to, it cuts against that sort of intrinsic value of the natural environment. I totally get that, but I think we can be sophisticated enough to walk and chew gum at the same time. So you can sort of try and put a monetary value around things, as well as appreciating its intrinsic value. And it is a way of attracting investment. And quite frankly, we are a marine, we are an ocean planet. This country is, as you were saying earlier, Helen, particularly special because of its marine environment. A natural capital approach would be incomplete on land without taking into account impacts on sea, not least because there are strong correlations between what goes on land and what goes on sea. The running off of forever chemicals affecting marine mammals, for example, and so on. So I think I think a natural capital approach is important. Marine biodiversity net gain, marine net gain will be what's important about that is you create the regulatory demand, which then supplies natural capital solutions to deal with it. I mean, that's what's happening with biodiversity net gain. You create a regulatory demand, markets form to supply natural capital, which delivers on what you're trying to achieve. So I think that's probably what the connection between those two things will be, and it depends on how, I guess, the marine net gain regime is applied in practice. What are your thoughts on that, Helen?
Yeah, and I think it also links with this sort of the strategic approach to be taken as well. And I think a strategic approach is really important in the marine environment. And this was also touched upon at that the recent Westminster Forum. Because the marine environment is very different to the terrestrial environment, and things happen at a bigger scale in a lot of cases. And so I think that a sort of natural capital approach will enable this more strategic, but also a more joined up approach between all the different parties involved in trying to deliver net gain or compensation or benefits for the marine environment. So I think it will, and I think it will also, well, I hope what it would also do is it would channel funds to specialists, so that you've got your specialists who know about, for example, restoration of seagrass beds, oysters, mussels, the active restoration measures, that if each individual developer was trying to do that separately, it could end up in a bit more of a piecemeal approach that might not be as effective for the longer term recovery. And I think it's in the marine environment, I think it's the way it's going to go. It is already starting to go that way. I see it as happening because of the differences in the environment as well.
Yeah. Great. Okay. Some comments here. Yeah, direct causal effect evidence significant is very hard to collect. Yeah, absolutely. Sue, the risk of monopolizing the Q&A, I'd like to go back a step and ask about Freeths setup, aims, and representational activities. That's been a superb and highly valuable webinar. Thank you. Oh, that's nice. Thank you for that. Appreciate that. So in terms of how we operate as a team, I'm guessing, is that?
And what our environmental work is, I suppose.
Yeah,
So I guess let's just big ourselves up for a moment, Richard.
let's do it.
Freeths has the reason Richard and I are both at Freeths is because we are both really, really interested in the natural environment and this area of law. And Freeths is the leading law firm that specialises in this, and it's been set up over the years by Penny Simpson, our partner. Penny is phenomenal. She's a real expert on these areas of law, and there's there's nothing about the natural environment that's worth knowing that Penny doesn't know about. So yeah, we both joined because we wanted to learn as much as we can really and be part of this team. And Richard, I'll let you talk a little bit about what you've been doing since you've been here, but
Yeah.
Richard's been really helping with developing the biodiversity net gain regime, not just in Freeths, but like in general, speaking with really influential people at conferences, in forums. And our sort of goal with the marine environment is to have a voice and be really influential in, as these regimes start to take shape, understand the law as much as we can, as much as possible, more than any other law firm really, and have a place at the table to drive forward the changes in the regimes in as positive a way as possible. So I think that's a summary. But Richard, you say a bit about what you've been doing.
Absolutely. So the marine environment lags behind the terrestrial environment when it comes to environmental law and policy, and I think both of us see that as a bad thing. And there's a lot that can be drawn into that and applied and it brought up to speed in its own way. It's not going to be exactly the same, but drawing that thinking into it. And it's just, given how important the marine environment is, it's absolutely crucial that we that it is taken seriously, and that we fully take an interest in it. And I cut my teeth doing a lot of NSIP, that's Nationally Significant Infrastructure Project casework at Natural England on offshore wind farms, port developments, and so on as well. And you could see from that the difficulties, the challenges, also with the rollout of the MCZs as well, the difficulties and challenges associated with that. But we absolutely need to get the marine environment right in terms of the law and policy of it, because it's how the ecosystem operates is exceptionally important to us all. Yeah, I hope that answers your question, Sue. Any other questions here?
There's just a comment from Pina that we've not addressed that
I'm
says,
sorry, yeah,
to define what significant means in terms of populations rather than individuals, we need a really good assessment on the population size.
Yeah, we do. We absolutely do. I fully agree with you. And Helen, you've had experience actually physically surveying marine mammals. I mean, do you have any sort of sense of whether that's whether that's a
well, it's hard.
drop in the ocean, or
So I'm sure a lot of people on this call know about marine mammal survey work, so I won't go into too much detail, but obviously it can be undertaken at a sort of smaller scale, like a localized area, or it can be undertaken at a larger scale. And I saw just this week that the recent Scans 4 survey has been published, or it's an announcement that it's going to be published. And so Scans is small cetacean abundance monitoring. So it's evolved over the past few decades from boat-based to now aerial as well, and it undertakes like the small cetaceans all around like the North Sea. So it covers a huge area, and so it obviously it has its limitations, but there's so many amazing scientists working on population monitoring, abundance estimation, and techniques for surveying as well that are evolving so quickly. And we're also dealing a lot with what we call like really big data, where you get a lot of information and then processing that into meaningful results. So there's a lot of work going on to assess the population size, but with marine mammal science, it's always going to be, you know, a work in progress, just given the subject matter and the their range where they are. Yeah.
Mm. There's some really interesting questions here actually in the chat function. So one of them is, given that cetaceans are protected species throughout their range, does the favorable condition target apply outside of designated protected areas? I remember coming across that query at Natural England. If you come across that, Helen, that is
I've come
it,
across it with respect to SACs.
yeah,
With
yeah,
yeah.
because
So
they're such mobile species, you know.
yeah, so an example I'll just share with you is the Moray Firth SAC in Scotland is designated in the 90s to protect a population of bottlenose dolphins, and it just is the very inner Moray Firth, so sort of the mouth around Inverness and Cromarty area. But over the past, it's well over 30 years now, studies have been undertaken by Aberdeen University, by St Andrews University, and by other organisations operating along that coastline, and now further south down into the north of England and even Yorkshire, that have found that that population, the protected population, their range is well out with the SAC, but the SAC is still really important for them. And so
Yeah.
the conservation objectives for that population now expand to the full population range. And so, for example, if you know, a wind farm was going to be designated off Aberdeen, for example, or not Aberdeen, let's give an English example. Let's stick with what we know, or know best. If it was going to be designated off the coast of Whitley Bay or Newcastle, then an HRA would be needed because it
Yeah.
would impact on those species. And interestingly, when I was last at St Andrews earlier in the year, someone told me that those bottlenose dolphins had been photographed in the Netherlands, and asked if that meant that it would extend to there. And so, I mean, I don't know. We would have to have a look at what the Netherlands said, but they are protected under European law, and what the Netherlands wording was, would that expand it? It probably would, because it's the species from that SAC are protected. So I'd have to have a look into that question a
Mhm.
bit more detail in that specific those specific
You
circumstances.
quickly
But
bump up against those transboundary, you know, multi-jurisdictional issues with, such a mobile
yeah,
species.
yeah, you
That's a
do.
really good question. Um, Great webinar. Be very useful to have a similar one for fisheries. I completely agree. And so that you know, this is just a taster of a longer, I think, a day-long course, Helen, that you're planning to deliver at some
Mhm.
point in the coming months, which will go in far more into depth into all of this, and I guess would include an element of fisheries in there too. Is that right, Helen?
An element of fisheries, yeah. Fisheries in itself is an incredibly complex and could be like
Yeah.
a whole day webinar. Yeah, it does come into conflict, but we do have some, you know, the new Fisheries Act and the Joint Fisheries Statement and the fisheries plans, which are attempting to be a bit more joined up. So it's a really interesting area. But yes, it would form a core component of the content of any such talk.
Yeah. And then there's a question here. Thank you very much for interesting presentations. Are requirements for the Marine and Coastal Access Act relating to activities impacting upon MCZs applied by land-focused regulators, e.g. Offshore local authorities, or wholly marine-focused regulators only? If only marine, can this cause issues, e.g. water quality? Thanks. That's an interesting question. I mean, the way the legislation is drafted, it involves decision makers which have an impact upon MCZ. So I guess it would allow that wider um, uh, remit to it. Um, uh, in my experience, it's mostly marine regulators that deal with MCZ impacts. But I don't think I've come across ones which deal with water quality where you're right, there would be a definite throughput there between, Ofwat, for example, and local authorities and MCZs. I don't know if you come across something like that before, Helen.
No, but I know we've got the coastal concordats in place to try and link
Mhm.
where there's a link between something happening at the coast and something happening offshore. And it's a voluntary agreement entered into by local authorities.
Mm.
So that would be worth having a look at seeing what that says. It's updated quite regularly, and it's
Mhm.
new local authorities are still joining up to it, or local authorities are still continuing to join up to it. So that it'd be worth having a look there. But I would imagine it It does, because we're seeing
Yeah,
this in the terrestrial environment, where like catchments that are impacting upon marine upon protected sites in the terrestrial environment. We've seen this with nutrient neutrality. Like
yeah,
the diffuse pollution is requiring assessment of those protected sites, even though the issue that's causing the impact is happening, not near the protected site, or not on it. So I'd have thought that it would, if a connection was made as part of the assessment process, that it would require assessment.
and the legislation would allow for that.
Yeah.
Well, I think we've just gone over the hour, so thank you so much, everyone, for joining us. I think, as we said at the uh, uh, earlier on, we're planning to do, well, Helen's planning to deliver a longer course, which will go into these details. And I just flick to the end of these slides here, because you have our contact details. If you want to ask us any questions, please feel free to do that. Happy to answer those questions from you. But thank you so much for your time today. And we'll make the
Yeah.
recording available to everyone as well who couldn't attend today as well.
Yeah, and the slides with the links as well,
Yeah,
so you can read some more on them.
great. Thank you, everyone.
Thank you.